Hello everyone, my name is Sanya Mahajan. I am a legal intern in LEXCLIQ company and today's topic of mine is law of torts. As we all know, torts means a conduct which is not straight or lawful, but or on the other hand it is twisted, crooked or unlawful. And thus here is the meaning related to the tort is the word tort has been derived from the Latin word tortum, and which means it twist, that is to twist. But thus a tort is an actor omission and another other than the breach of contract which gives rise to a injury or harm to another person amounts to a civil wrong for which court imposed the liability as per the law. So guys, this is about the meaning, and now here we discuss about some definition related to tort. Tort means a civil wrong which is not exclusively a breach of contract or a breach of trust as per section 2M, that is under Limitation Act 1963. There is another definition which is given by Salman, that is, it is a civil wrong for which the remedy is a common law action for unliquidated damages and which is not exclusively the breach of contract or breach of trust or other, merely it is an equitable obligation as per Salman. And further, there was a definition which was given by Fraser, that is, it is an infringement of a right in rem of a private individual, giving a right for compensation at the suit of injured party. With this, we come to know that the basic idea related to these definition is that firstly, the tort is a civil wrong, and secondly, every civil wrong is not a tort, and there is another civil wrong also, the important of which a breach of contract and the breach of trust is essential. Here are some essentials of the tort which I mentioned in the, that is, number one, there must be some act or omission on the part of the defendant, and further secondly, there is the act or the omission should result in the legal damage or that is violation of the legal right and vested in the plaintiff. Let us study about it in detail about the essential part, that is the act or the omission. In order to make a person liable under a tort, he must have committed any act which he must not be expected to do as per the law, and he must have omitted to do something which he was supposed to do it. Finally, there is a legal damage which is an essential part of the tort, that is, it order to be successful in an action related to tort, the plaintiff has to prove that has been a legal damage which is caused to him. In another word, it means that it has to be proven that there was a wrongful act which was caused as a breach of a legal duty. Then there is a tort can be committed by how, which is the situation, that is, number one, firstly by negligence. Negligence is the one most common of the tort cases. As per the negligence occur when tortfeasor, the person responsible for committing a wrong, is careless and therefore responsible for the harm which is caused to another person. Element related to negligence is when he neglect his duty, when any breach has been committed or any caution or any harm. These all four elements are to be proven as per the negligence. Secondly, there is an intentional tort. Intentional tort requires an intended act which is done by a wrongdoer against another person. Some intentional torts can be also be a criminal cases, and common intentional tort includes assault, battery, trespass, convention, defamation, and false imprisonment, intentional infliction of the emotional distress. These are all about the common intention torts. This was all about the introduction to related to the tort, and if you need any information related to it, please do write in a comment section, and please do subscribe this channel LEXCLIQ.